Hello again. I'm back, following up on today's earlier videos. Um, we've been keeping an eye on the Checker foot soldiers of Rachel Hudson, who stole our devices. Hence the previous videos. The devices were stolen from my house, and as I mentioned, I was subject to physical and psychological abuse by Northumbria Police, and the devices were essentially taken to Ettal Lane in Newcastle, and they were hacked immediately. And they come up with a strange, quite a almost childlike analogy, where even though you know they've been hacked, so once they've been hacked, in theory they should be returned. Um, they say that they can't be returned because the investigating officer has to authorize that and he is on leave, which is not at all convincing. It's a quite a childlike ruse. I think the investigating officer in this case is Officer 1812 Lloyd, the very same who assaulted me in the back of a police car outside my property, leaving me with a feeling of a dead arm and shoulder when he lost his temper. When I started to question the validity of what he was doing, he was very sloppy. He let quite a lot of things go. It's quite crude in many ways. We've had a look at his service record actually since the theft of the devices, and we've got quite a lot to go on that, but I'll come back to that. And we arrived today to ask about the devices, and we were told by somebody in the control room the investigating officer would call us tomorrow. Let's see if he does. It's quite interesting because um, Rachel Hudson, I think, is in a lot of trouble now because, as I noticed in previous videos, essentially she's accusing me of harassment, but the harassment is actually from her. And the big error she has made is this accusation of spray painting her car, because that was allegedly done in January and February, and obviously we're now in November, so you wouldn't leave it to fester for so long. It's clearly a ruse, and effectively they can't sustain it. She knows that. She knows I didn't do it. They did it as a pretext, to be able to raid this property and steal our devices. She knows she can't sustain that, and that will then obviously open the door for defamation and so on. I'm not a litigious person, but I think she's, yeah, I mean, it's, I've dealt with a lot of corruption cases over 30 years, and this is probably the biggest mistake I've come across in terms of trying to create a pretext to do something bad. Yes, Britain is a police state. I think we've seen that today. Farmers being arrested and so on and so forth. Um, Actually, I'm very encouraged by what's happened because in resorting to aggression, they put themselves in a position where to destroy me, they have to destroy themselves. So it's going to be interesting to see what happens. Fundamentally, as I've said in previous videos, what they're trying to do, and if you look at the related channel to this one, at Gary Stockdale 171, the FCA, South Tyneside Council, and Hudson, all of which are implicated in quite serious corruption and conflicts of interest and so on, are trying to create a situation where I'm not around for the Wealth Tech trial in 2027. We know that, we've been researching it and so on. I will now return to the second part of the statement, which I wrote to Southwark Crown Court and to John Dance's legal representative, Josh Hart. I'll read it and I'll depart when I need to make um, add context. Yeah, it's a quite tiring day, so bear with me. So, returning, this is continuing from the first part. My fears were further stoked after reading Therese Chambers' Do the Right Thing speech. The speech, in my opinion, took an appallingly nonchalant stance towards the scandal, also seeking to cultivate a perception that the FCA had acted expediently. I've covered a lot of this in the book, Lost the Races and the other channel. And she's actually since done a Do the Right Thing 2 speech, which shows the extent of arrogance and the real corrosive nature of this conflict of interest um, between being a regulator and a prosecutor, which I've covered extensively. I complained, so back to the statement, I complained to the FCA about the speech. I believe clients of Vertum Asset Management took the same action. I do not recall a meaningful response. I do know that clients, elderly, vulnerable clients of Vertum Asset Management took exception to the speech and also complained. But I think, as with myself, they were treated with contempt. Again, this is the sheer arrogance and this corrosive conflict of interest between the regulator and the prosecutor, and effectively elevating the preservation of the reputation of the regulator above, so I then subordinating the welfare of the victims of their catastrophic errors to that objective. So back to the statement. Throughout the process, I'm concerned about the perverted concept of prejudice to shield the FCA from accountability in the context of the conflict of interest between being a regulator and a prosecutor. I cannot see how regulatory failings could excuse any misuse of client assets. As I've commented extensively both in the book Lost the Races and the other channel, prejudice is a ruse. I've shown you how Starmer's used it, I've shown you how the FCA use it. Essentially what they're trying to do is they're trying to say that by holding them to account for catastrophic errors which have harmed consumers, this would somehow prejudice a trial, which is complete nonsense, because you cannot excuse the misuse of client assets, whether the regulator is on point or not. So next, back to the statement. Tom Malik, formerly of Malik Melville, contacted me and suggested I talk with BDO to assist them with intelligence to aid the special administration process. I did this, I think it was in August 2023. And yes, as I documented in the book, I was somewhat alarmed about the speed of their progress, the standard of their questions, and that in the context of the time it was taking them to get to a conclusion, and also in consideration that clients were paying the bill for this special administration process, which was largely as a result of possibly somebody misusing client assets, and if they did, made easier by catastrophic failings of the FCA. So back to the statement. I spoke with Matthew Stone in August 2023. Whilst I appreciated the complexity of the process, and it was a complex process, you'll note from the emails I've posted on the previous, on the other channel, sorry, that essentially I was concerned about aspects of this, and also I'd recommended this process take place in July 2021, when, had it have done so, had the FCA, with the assistance of a BDO or somebody equivalent, undertaken this activity 2 years earlier, the burden on clients would be substantially less. So I was disappointed with the level of questions and the perceived degree of progress. This was in the context of client hardship, stress, and accruing fees. So essentially, that's how I felt, and I'm bringing the context to the statement. So back to the statement again. Vinny Beddy, formerly of Vertum Asset Management, asked if I would speak with the Times newspaper about the failure of the FCA to act sooner. I was not welcoming of the exposure, but thought it worthwhile in highlighting the injustice clients were suffering. So I did that. It's the Jonathan Ames article on the Times, and I provided it with a site of emails that the whistleblowing actually had occurred, pretty much what I've published on the other channel. And we kind of hoped that it would sort of embarrass the FCA into actually saying sorry, and also um, perhaps working with the Treasury to provide some assistance to people who were suffering as a result of their catastrophic errors. Shortly afterwards, back to the statement, I received an email from Jennifer Hepworth of the FCA seeking to advise of their intention for a compelled interview. She viewed me as a key witness, ultimately desiring in a witness statement. Not really a lot to add to that here, so I'll skip on to the next paragraph. I asked why it had taken the Times article identifying me as a whistleblower to contact me, as their investigation had begun months prior. She claimed her team were unaware of my status as a whistleblower. This was odd, as I had given prior consent to the intelligence team to waive anonymity. So essentially, when I went through this process with their whistleblowing team, what they call their intelligence team, at the end of it, the chap said to me, did I mind my name being revealed, to effectively help them to pass on information within the organisation. And I've published this on the other site, at Gary Stockdale 171, where I waived that and I said, yep, you're free to name me. I'm more concerned with the risk of clients and the potential damage to the integrity of the industry. So um, her comments here didn't reconcile with the evidence I published on the other side. Back to the statement. I made it clear I could not provide a statement until I was satisfied how the above mentioned conflicts of interest would be managed in the context of a fair process. So, as I've spoken about extensively through these series of videos, and also the book Lost the Races, there is this clear conflict of interest between a regulator trying to show it's achieved its regulatory objectives of protecting consumers and also being a prosecutor. I said, how are you going to manage this conflict of interest in the context of looking after the victims and a fair trial? They weren't willing to engage on that, so I was unable to provide a witness statement. My own research had identified concerns regarding the procedures followed by the FCA and Northumbria Police in seizing the WealthTech servers and John's devices, and this was a particular worry. This is true, and this is exactly the process that we're suffering right now. So effectively, what my concerns were here. So they've gone there to WealthTech, Cobalt Business Park at the time, not an office I ever worked from, and they'd taken the WealthTech servers and they'd taken John's devices, taken them away, just like they'd done to me in their sort of checker-style raid at the behest of Judge Rachel Hudson. They'd take them away, and they then sort of hack them, download all the information and so on, and they can then use that to provide questions to you, and you're not able to have recourse to that same body of data in answering that. So they'll often, so in my instance, for instance, when they were using this nonsense ruse about spray painting a car. They were quoting dates in January and February, in November, and saying, "Where were you?" Obviously, to help prove where it was, or provide an explanation of where it was, I needed my devices, because I do a lot of appointments and so on, and there's a lot of things on there which could have allowed me to say I was doing this on that particular day. They know that. They were trying to trick me. It's very, very, very crude. I use the term checker, but actually the Russians were actually very methodical in their interrogations. These were sort of thuggish foot soldiers in many ways, lacking in intelligence. So in the case of John, they would have taken the Weltec servers away. They would have, they would have understood that that was probably one of the main bodies of evidence. And within that body of evidence, probably, I think, contained stunning examples of their own incompetence. And they would have been effectively in control of that. So I guess John, for some time, was facing questions about, so they were cherry picking data and emails and so on and presenting with him and saying, what about this, what about that? But for him to be able to answer it properly, he would have needed to have recourse to that same body of evidence. So it's the same trick. And I don't believe that is consistent with the ECHR framework. It clearly isn't. Um, it's quite nonsense. And what my point is here, I said to them, is, look, I understand why you took them away. You need to make sure he can't delete things and so on and so forth, but you should have been able to provide him with read-only access of that same body of evidence, so he was able to respond to the allegations being put to him. And that should be done in a very transparent process to make sure that that same body of evidence, which is likely to show stunning FCA failure, has not been manipulated and used in a way which is consistent with this corrosive conflict of interest between being a regulator and a prosecutor. So this is part 2. That's it for now. I will come back soon with further parts of this statement which I've submitted to John's legal representatives and Southwark Crown Court. Take care, bye.